Good afternoon, everyone. My name is Kristen Salas. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. For those of you that are not familiar with DVAP, as we affectionately call it, we are a joint program with Legal Aid of Northwest Texas and the Dallas Bar, and our primary mission is to match low-income Dallas residents with private attorneys that will do their civil case pro bono. One of the most common types of cases that we come in are folks that are needing to get their wills and the powers of attorneys done. And this is actually one of the easiest types of cases that you can get started in order to start doing pro bono. So we are blessed today to have Brandy Baxter Thompson with us to teach us all about how to do our drafting for wills and powers of attorney. Brandy is a probate attorney at the law firm of Land, Smith, Sosolick, Baxter Thompson, and Johnson. She's board certified in estate planning and probate law, and her practice is dedicated to litigation involving estates, trusts, fiduciaries, such as executors and trustees. She has her JD from Texas Wesleyan and her BA from Austin College in Sherman. She has been elected by her peers as a Texas super lawyer since 2017. And among her other awards are the Nikki DeShazo Pro Bono Award from the Dallas Bar Association and the DVAP Ken Fuller Outstanding Mentor Attorney. She has spoken numerous times on probate issues and estate planning issues, and we are very blessed to have her give us information on how to do our wills and powers of attorney. And just if you have questions, do put them in the Q&A section at the bottom, and if we have time at the end, Brandy will get to them, and if not, we will you can email her to get your questions answered. But without further ado, I will turn it over to Brandy.
Thanks, Kristen. I appreciate that introduction. Greetings. Good afternoon. I was just talking with Marital and Kristen before about, whether we were going to ever go back to the BELO or the Arts Museum, or not Arts Museum, the Arts Mansion, whatever it's called at this point. And they said it's been so successful. And I'm sitting here watching all these people come in, and we've got 132 attendees, and we never had that many people show up at the BELO, so this is really great. And I will tell you what I'm going to go through today is I called it the do's and don'ts of drafting wills and powers of attorney. If you've attended this CLE before with my presentation, it's going to be very, very similar to what I've done in the past. And I've got a PowerPoint that we're going to work through here in a second. It is available if you have, if you'd like a copy. I believe it's either going to be mailed out, or if it's not, then you're welcome to contact me for a copy of it. You're also welcome, if we don't have time at the end to get to questions and answers, you're welcome to email me, and they're going to put my email address in the chat area. In addition, it's on the cover of the PowerPoint that's going to be sent out. And lastly, before I get into the substance, I apologize for my voice. Was really sick the last few days, and I was hoping I would be well enough to give this presentation today, and I am, but my voice is still a little croaky, so I apologize for that. So without further ado, let's get to the presentation. And let's see here. So like I said, we're going to talk about the do's and don'ts of preparing wills and powers of attorney. When you take on a DVAP client, the DVAP client is typically someone that doesn't have a lot of assets. Obviously they're going through legal aid, but there are definitely certain things that it doesn't matter. The size of the estate, the nature of the assets that have to be addressed in the will in order for it to be a proper will. and additionally, regardless of the assets and the type of asset and the size of the estate, going through with the client, powers of attorney, what they mean and how they work, and really being able to explain that to them so that they can make, an informed decision as to who they would appoint as an agent and when they want it to become effective is really, really important. So I'm not going to get into obviously anything related to tax. I'm not a tax lawyer. I don't give tax advice. And obviously if anybody you start digging into something with them and there's a tax issue, then that's going to be beyond this, I think, the scope of what we would normally deal with in DVAP. But so we're going to talk about basics and bearing in mind the type of client that you're going to be dealing with DVAP, but I will go a little bit beyond that. Let's see here. There we go. So the first thing to look at, and again, regardless of the client, DVAP or private client, the first thing that I always consider is looking out for elder exploitation and undue influence. Who is your client? And I, if you've ever prepared any estate planning documents, I'm sure you've run into this issue where you have the daughter or son or niece or nephew of the person for whom you would be drafting the documents that may make that initial call. That is, regardless of the situation, that's always a red flag to me. I think, my first thought is, okay, is this person that I'm going to be preparing documents for incapable of figuring out how to call a lawyer and ask them questions? Because if they are, then do they have capacity? That's where my mind goes. And as somebody that deals with a lot of this litigation, that's where my jaded nature, if you will, comes in. But I think it's really helpful and it's something that all planners should really think about and consider. There are a lot of occasions where you just have somebody that is either they honestly have a family member that they just expect to do everything for them because that's just the dynamics of the relationship, and that's fine. Or they just need some help in order to accomplish their goals. And it doesn't require a lot of capacity to be able to sign a will or sign a power of attorney. It's a fairly low threshold of capacity in order to do those things. So just keeping that in mind. But the bottom line is you have to be able to speak directly with the client. You need to meet with that person, and you need to meet with them alone. If you suspect that there is any elder exploitation or specifically, then you need to report that to APS. And I think we have an obligation in some respects to do that if you think the person's being taken advantage of. And this may come in the form of, okay, mom needs, or a neighbor or a friend needs you to prepare a deed that transfers their house to me. I mean, that obviously, I think most of us would go, okay, that doesn't make any sense. Why would they do that? There are some legitimate reasons for doing some of those things, but I think as a singular item, that's something that should definitely raise red flags, and you should be cautious of. And I think the reason also to report this to APS if you feel like there's some exploitation going on is if you just say no and say, I can't help you, or I just don't think this is appropriate, or you're just afraid of offending anybody, that person's going to keep looking, and they're going to eventually find somebody that's going to be able to help them, that is either just not as diligent, or maybe they take a different tack and are able to convince somebody to prepare these documents. When you have a married couple, there's obviously that's a joint representation. I think a lot of people don't think about it. It's like, well, they're married, their goals are the same, etc. Well, that's really, it's not always the case. I think you need to include a waiver of the conflict in your engagement letter when you have a married couple, and discuss with them that if they are ever in conflict with each other as far as how to prepare their documents, in that, in a joint meeting, one they'd say, oh yes, we want it this way, and then the one spouse calls you later and says, actually, I want to make a bunch of changes, but don't tell Susie about it. That's a big no-no. That's a conflict, and you can't continue to represent them at that point. And I think you have to make that really clear at the outset when you are meeting with them. Always ask if there's any kind of prenuptial or partition agreements that address their assets. You're going to need that in consideration of what you're preparing. Can ask about prior marriages and children. Blended families create the biggest issues and are probably the most highly litigated of any situations. When you have children from a prior marriage, that automatically should set up some different questions that you need to ask and dive into. If you've got a couple that comes in and doesn't have children, or they've been married for 30 years and they have 2 children, and then they have grandchildren, and they've never been divorced, never been married before, then those are usually pretty simple to deal with. But you definitely need to go through and ask these questions. And I usually provide my clients with, because I do some planning. I don't do heavy tax planning of any kind, but I do some simple estate planning for people. And I always send them a questionnaire to fill out. And I think that's a really good best practice as well, because then you've got them filling out the paperwork for you. It cuts down on the amount of time that you're spending with them just to get the basic information. And then also it's giving them an opportunity to outline, all these details for you. And then you have it, in your file. And it may also lead to you asking more questions when you do have your initial meeting. So I'm a big fan of the New Yorker or the cartoons. So I've got these kind of riddled throughout here, just as a little bit of amusement. As I mentioned, we're not going to be talking about any death taxes or estate tax. Right now the tax exemption is $11.7 million per person. A couple would have, of course, what is that, $23.4 million between them. None of those people are going through DVAP, obviously, but I just thought this was kind of cute. One thing to note, though, and again, this isn't going to impact DVAP, but it may impact, some of your clients. In the end of 2025, the sunset provision is going to come in to play, and the estate tax exemption is going to roll back. I think it's going to roll back to 5 million, and then with the cost of the increase based on inflation, it's going to be somewhere in the $6 million range. Still a considerable amount of money. So the basics, we've kind of talked a little bit about this, gathering information from the client. I'm going to go through this actually in more detail, gather what information to gather, the points of discussion, and then the formation requirements to make a will. The actual creation of the will is going to be something that shouldn't take that long. You're going to spend a lot more time gathering information and kind of assimilating it before you actually, than the time you'll probably spend on the actual drafting. Again, if you have a questionnaire and having these questions in there, it's a really, really good idea to send that up beforehand, so you've got all this information. I always, ask for dates of birth, current phone numbers, current addresses for any of these people. You definitely want to make sure that you're checking into whether you've got any special needs, children or grandchildren, whether there's anybody that's estranged. excuse me. This is one that, obviously nobody wants to dive into, but it's extremely important. And I will tell some more stories as we go along. I had a client that came in and filled out the paperwork and prepared her will. We were in the will signing, and I was walking through the will with her about her children, and she said something to the effect of, she mentioned another child, and I just stopped, kind of went white. This was before she had signed the document, and I asked her, I said, you have other children? And she said, well, yes, but I don't know where he is, and I haven't seen him in years, and I don't, I've kind of disinherited him, etc. And I said, well, we got to change all of this. One of the elements of testamentary capacity is knowing who the natural objects of your bounty are, knowing who your family are. And if you prepare a will and it identifies 2 out of the 3 children, it's going to on its face look like they don't know who their children are. So I think it's extremely important, regardless of how they consider some of their children, they've got to be identified in there. And I think you can include language that says that they're specifically not providing for them. Sometimes it's good to go into the why in the will. Sometimes it's not. You just have to make a decision on that. But regardless, I think you want to make sure you very carefully paper that in your notes. In addition to family, you want to identify the assets, any real property. Do they have anything special in their personal property? Any collections, valuables, collectible cars, artwork, jewelry, etc. You want them to list all of the accounts that they have. If there are accounts that would have a beneficiary designation, who is the beneficiary? Do they have a safe deposit box? And do they have any interest in privately held entities? And, for a little bit more sophisticated client than most of our DVAP clients, excuse me, it's really important to have this information, because if they have a will that leaves everything to Susie, but then they have all of their accounts payable to Johnny, then Susie's not going to end up with anything when the will's probated. And so it's really important to gather this information and be able to really explain clearly to a client the difference between probate assets and non-probate assets, and what assets pass according to the will and what pass according to a document that says who the beneficiary is, in order to make sure that you're accomplishing their goals. And I have had some clients, and even some fairly smart and sophisticated clients, that just it's hard for them to really kind of conceptualize some of this. And so a lot of times what I'll have them do is I'll just tell them, look, tell me what you want the end game to look like. Who do you want to get what, and what circumstance? And then I'll put together the machine that'll make that work. And of course go over it with them, but sometimes it's just easier to deal with the client, coming from the end perspective, and then you kind of backing it out and telling them how it has to work. Most of the cases that you're going to deal with, obviously they're not going to own any real property outside of Texas, but maybe they've got some mineral interest that's not really producing, but it's in Oklahoma. That all should be considered. I think best practice is to put property outside of Texas in a trust. If you don't, then you're going to end up having to probate their will in multiple states. And this kind of takes care of that on the front end, and allows for transfer based on, what it says in the trust. The oil and gas, if they have oil and gas royalties, mineral interests in multiple states, it's always a good practice to put those assets in a trust. And you may have to work with lawyers in other states in order to effectuate that. It's obviously you're going to have deeds drafted in that state. You want them drafted properly, and you want them drafted by a lawyer that's licensed to practice in that state and that can make sure they're recorded properly. The trust can be a Texas trust, but as far as transferring the assets into that trust that are from outside of the state, you will have to engage counsel outside of Texas. The tangible personal property, that's the most common specific bequests. Personally, I hate getting into those details with clients because sometimes it's really hard to figure out what they're talking about. But if they have something really specific in mind, you can put it in the will. Otherwise, I encourage people to prepare, their memorandum, and I always provide for that in my will, that they can have a memorandum. And I think, to take it one step further, in addition to a memorandum, taking a picture and attaching it, as to what you want to go to certain people, especially if you've got multiple people and multiple items, that just makes it a little bit easier. As I mentioned, the beneficiary designations are going to play a huge part in, how their assets are going to be distributed, and, need to be in concert with what their will says. Another consideration, though, of course, is to make sure people understand that there's a way to avoid probate if you can have everything go passed by beneficiary designation. You can do a transfer on death deed if they have a house. Cars are pretty easy to transfer without a will. You don't necessarily have to probate a will to transfer a car. So if somebody has a house, a car, and a bank account, it's always best to have a will and have that as a gap stop. But if there's a way to be able to have their entire estate passed outside of probate, that to me is optimal. It saves a lot of time and money, and quite frankly, with the amount of time it takes to have a will admitted to probate these days, it's obviously going to be in everybody's benefit to try to have everything pass outside of probate. So if they have a safe deposit box, make sure that they have, best practice is to have a file folder with the key and a list of the contents. They can, on the contract with the bank, add persons that are permitted entry into the box. It does not give them ownership of the box, but it does allow them to enter the box. That's really important, especially if if they decide to keep their will in the box. I would, make sure that that's understood in this file, so that if somebody's looking for it, they know that that's where the will is located, if that's where the person chooses to place it. I will tell you, getting into safe deposit boxes these days through some of the banks has just been like the most cumbersome process, in dealing with getting the courts to enter orders, and the banks sometimes they won't honor the order. I was involved in a case where it literally took us, I think it was 6 months of going back and forth with the bank in order to finally get into the box to get the will, and that's where the will was. So that's not my favorite place to store a will, but I understand if people want, to put valuables and that kind of thing in there. Privately held entities, again, this is not going to be your DVAP client, but if you're dealing with simple, you can still have a fairly simple non-taxable estate with somebody that has interest in these types of entities. And they unless they're held in a trust, they're going to pass according to the will. And I always want to look at the formation documents, because you need to see in the document if there's any restrictions on transferring it. There may be a requirement that it be, offered to the other owners at the one owner's death. How is that going to work? How is that going to be valued? The client needs to really understand that, and you do too, because when they do pass and the beneficiaries come to you, the executor comes to you, having really good notes on that ahead of time is going to, save everybody a lot of time. So gathering information, family and friends, charities, provisions for pets, who are going to be the beneficiaries. And I will tell you, I was just talking with a couple of my partners the other day, and we've unanimously agreed that the most complicated estates, or the complicated estate planning, comes from couples or single people that don't have any children, and they come up with some of the most interesting ways that they want their assets to pass. These all of their nieces and nephews, or a variety of charities, or if they've got pets, which I have pets. I always talk to people about that and make sure that there's something that they've considered, as far as who's going to take care of the pets when they pass, and is there going to be enough money to take care of them. People, especially people that don't have kids, I mean, they're really not just people that don't have kids, but we love our pets. We want to make sure they're taken care of. But whenever you have, and I've seen this where we've had to go to court and identify heirs when we have a will. And we do that when a class of persons are identified as beneficiaries. So if you have somebody, that says, I want to leave it all to my nieces and nephews, make sure you really have a little bit of a family tree established at the beginning of your will. And I would identify, I'm a single person, or I'm a married person. I have no children. I have these siblings. My sibling John has these children, and put their full names and put their dates of birth. And that's going to be really important for a couple of reasons. A, it's going to definitely obviate the need to do any kind of heirship when it comes time to probate that will, and if they're leaving it to their nieces and nephews. If they just say nieces and nephews, you're going to probably have to do an heirship, which to me defeats the whole purpose of having a will, is to avoid having to go through that process. And secondly, making sure you put dates of birth in there so that it's really clear at the time when they pass, are any of these people that are going to inherit minors? Because obviously that's going to create some other issues. If you're really going to do a diligent job with the will, you're going to make sure there's a trust that's established at the time that the person dies, if any of the beneficiaries are under the age of 18. And if you're, for example, if you're leaving it to nieces and nephews, then you can make their parent or parents the trustee of that trust for the niece and nephew. Another one of my little funnies here. See, everything I have, son, I have because your grandfather left it to me, and I see now that that was a bad thing. Giving you the unfortunate news that you're not going to inherit. Other information, trusts, obviously, if they have any trust, they may not have set up any trust, but maybe they're the beneficiary of a trust that their parents set up. You want to always have the full document. If they have any powers of appointment in that trust, you need to know that to be able to explain to them what that means and how to exercise that, and whether they want to exercise that. And I'm not going to dig into powers of appointment any more than that. But I will say, I think at our next probate section meeting, the meeting is going to be discussing powers of appointment. So if you have any interest in that at all, or really just want to be more educated in that topic, I would strongly encourage you to go. I think it's next Tuesday at noon. Premarital partition agreements, obviously those can have a significant impact on the assets, whether they're community or not. And if they've gone through the trouble of creating these documents, they may have some different ways that they want their estate planning to pass. And you also want to discuss with them what they mean in light of what their will is going to say. The other things, of course, you want to discuss with the client is, and we'll go through these in more detail, is who's going to be the executor, who's going to be the trustee, making specific bequests, and what kind of contingent disposition do you want to have. if everybody that's named as a beneficiary is not around. I always ask for at least 2 alternates. You really, having just one person is never a good idea. Sometimes they'll think, well, I can't think of anybody. And if they honestly can't, then there are some provisions you can include that allow, for somebody else to appoint somebody later. That's something to discuss with them. You want to talk about executor compensation. Do they want to include it? Do they not? I really hammer with clients about the fact that it is a lot of work. It takes a lot of time. It's a pain. And, asking somebody that's not a beneficiary, or somebody that, especially when the estate's a complicated estate, to take on this task and not receive any compensation is just, it's not fair in my opinion, but the client can do whatever they want. I just give them all the facts and kind of outline to them what it is. Also explain to them that the person may choose not to serve in that capacity, especially if it's a friend or business partner. They may say, I don't want to do this without some sort of compensation, or at least, some sort of token to cover the time that they're spending. I always include language that allows for the executor to make a non-pro rata distribution and discuss, do you want to give them the final say if the beneficiaries can't agree on how to distribute the personal property. If there's any trust created, such as, like I mentioned a minute ago, a contingent trust for a minor incapacitated person, make sure that the client gives this some thought and as to, is there going to be compensation? Is there anybody that the client would not want to serve? And do they want to require some bonding? I mentioned earlier the memorandum on personal property, and some things to consider. Specific bequests, discuss, class of items versus specific items. Discuss with them about making a specific bequest of real property. A lot of times they'll leave a piece of property to somebody, and then if they've sold it, explain what that means, that they're not going to get the dollar value of that. The gift is just going to completely lapse. Though when you're writing a will and you have, the children that receive, or friends or whomever, obviously if it's a charity that's going to be the beneficiary, then you don't typically have to worry too much about this contingent disposition. But I think it is a crime to have a contingent disposition at the end, that if everybody's deceased or then everything just passes to their heirs at law. That's going to require there to be an heirship. And, I've been involved in a couple of cases where, if all their children are gone and they don't have grandchildren, it's going to be it can be an extensive heirship proceeding, because you're going to have to go up to their parents who may be dead, especially if they're quite a bit older. If you've got somebody dying in their 70s or 80s and they don't have any descendants of any kind, and you don't have an alternate, a contingent disposition that provides for, an entity, like I said, charity, alma mater, etc. It's gonna cost a lot of money and take a lot of time to determine who's going to receive those assets. So, will requirements and drafting considerations. We look to our estates code as to who can execute a will. Like I said, it's pretty simple. They just have to be over the age of 18. And if they're not 18, they can, if there is or has been married. So if they're allowed to be married under the law, then they're allowed to execute a will. And then if they're allowed to enter the armed forces and they're not 18, then again, they can also execute a will. It must be in writing, signed by the testator, or another person on behalf of the testator. This is a pretty rare occurrence. Most of us will never deal with this, but if you have somebody that's, maybe they've got, ALS, and it's to the point where they're mentally there and they can talk, but they can't move their hand, or they've had some sort of debilitating issue where they, have had a stroke and they can't write, or, they're mentally okay, then they can direct somebody to sign for them. And then the last requirement is that they have 2 or more credible witnesses who are over the age of 14. They have to subscribe their names to the will in their own handwriting and in the testator's presence. And that's what it takes to prepare a will. Now, obviously, there's other wills we can do as a holographic will, and that's just has to be wholly in the handwriting of the testator. It doesn't have to have any witnesses. I think best practice, most people that are doing a holographic will are not doing it at the behest of a lawyer under a lawyer's supervision. I do know some people were doing this in COVID because they wanted to redo their will, or they wanted a will, and they were approaching lawyers and they just didn't want to get out of their house. And so they were telling them this is, sending them the language that they needed to prepare. But the best practice is to date it and to sign it, and keep it in a real safe place, make a copy, scan a copy. Self-proved will, most of us are going to create self-proved wills, which, you can either do the self-proving affidavit that you'll find in the code, or do a simultaneous execution attestation and to make it self-proved. It doesn't have to be in order for the will to be admitted to probate for it to be a valid will, but this obviates the need to have the witnesses come to court and testify. The section that I'm citing is, and I hope you guys can see this. Oh, here we go. That section is where you'll find the form. And again, you should receive this PowerPoint so you can look these things up yourself. Like I said, it avoids the need for the witnesses ultimately to come to court. And it also provides, because it has to be notarized, if the witnesses, if something happens to the will, or for some reason you need the witness to testify, you've got the notary can also serve as a witness if one of the witnesses is unable to. And I have seen most lawyers are really careful about making sure a beneficiary is not signing the will as a witness. I have seen that happen, but I think the case law allows for the notary signature to serve as one of the witness signatures. And again, like I mentioned, you've got this simultaneous execution, attestation, and self-proving language that you do. Some lawyers don't like to use this. They just like to have that extra affidavit attached. I personally use the simultaneous execution in my wills. It's really a preference. I think either one obviously is valid. This is new. I think it's been a few sessions ago that this was added, but the testator can give a person an authority to designate an administrator. In this, I kind of alluded to this earlier. The designated person can serve, and this is not the person appointing, but this is the person that's being designated. They can only serve if all of the persons that are named are, dead, disqualified, or unable or unwilling, and the designated person is not otherwise disqualified, meaning they have never been convicted of a felony. There's not some conflict of interest with them serving as the executor. And then the magic language that we want to make sure is in every will allows for an independent administration. Some things to remember when you're doing the drafting. As I mentioned, identify all immediate family members, include the dates of birth, and then define your children, grandchildren to include or exclude stepchildren or adopted children. And there's frequently situations where child was never adopted. Their dad is their stepdad, but that's their dad, and they've never known anybody else but that person. And that gentleman might choose to treat them as their biological children. And I've seen that a lot in wills where they'll identify the class and they'll say, I'm going to treat them all as my children. Some other things to consider, as I mentioned earlier, non-pro rata distributions of the tangible personal property. Unfortunately, that's a lot of times that's where the biggest issues comes up, is who's going to get mom's china or silver or furniture or furnishings. And if you've got kids that cannot reach an agreement, it's really good to have the executor be able to break a tie or to have some sort of other mechanism in there. I will always try to include a power of a sale so that that the executor has the authority to sell any of the property outside of a necessity to sell it. And then, of course, I always include a definition of incapacity. Codicils are documents that basically are amendments and restatements of a will, similar to an amended and restated trust. Codicil, typically will change an executor or change, add some specific bequests, take out some specific bequests. They're perfectly valid if they are created in the same manner in which a will is created. And they typically, they're republishing the will. So they are another document that would have to be probated once the person passes away. So the will and the codicil are, kind of treated as one document. I've had this in here. I think we're at a point where we're not necessarily having to worry about this as much, but I think some of the things that we learned through COVID-19, and obviously it's still here and with us, but not obviously at the same level that it was before, thankfully. I think some of these practices are really good practices. And I think, making sure everything is sanitized and, asking if people want to wear masks is a good practice. Talking to the client about this beforehand is always good. I mean, I know there's some law firms right now that I visited that they require you fill out paperwork before you go in, stating that you've been vaccinated or that you'll agree to wear a mask. And I think most smaller firms are not quite that vigilant, but it's definitely something to keep in consideration. At a minimum, just keeping sanitation good. One thing too, and I was just talking to my partner yesterday about this with trust. Trust, to be a valid trust, it does not require a notary or witnesses. But I think a best practice is to have a notary, to have that signature notarized. If you ever have issues in the future, it's a lot better to have a notary guaranteeing that this is their signature, so that there's no question about forgery, especially if you're having multiple people sign the trust agreement and siblings, something of that nature. So I'm going to dive into powers of attorney, excuse me, and kind of getting near the end here. So I'll run through this a little bit quickly. So what is the power of attorney? It is a very, very powerful document that allows somebody to take actions on behalf of the principal. The agent is a fiduciary, and they have fiduciary duties to the principal. The principal can ask them to account to them for any actions that's taken. There's the form that we have in the Texas Estates Code provides for a litany of actions that can be taken by the agent. They can be limited. They can be all inclusive, with striking that O provision that says everything that's identified here, they have the power to do. You can create limited powers of attorney for things such as, real estate transactions, or even a specific piece of property, transaction. If you want to give somebody the authority to sell property for you on your behalf, you can do that. But most of us are going to deal with just a pretty straightforward, simple power of power of attorney that we'll see the form that is under the Estates Code in section 752.051. So the durable power of attorney does not lapse because of a passage of time, unless the instrument created the power of attorney specifically states a time limitation. The other type of power of attorney, of course, it's called a springing power of attorney, and that isn't effective until a later date. I always mentioned about the fiduciary relationship, and this is something that I think it's really important to make sure that you explain to the client that's the principal. I ask them would you trust this person to have access to all of your bank accounts and all of your assets right now? And if they say no, then they either need to not have that person be a power of attorney, or you need to just kind of delve into that a little bit more. Why is that? Is that just because you don't want somebody to take control from you? Is this something that maybe you only want to have effective if you are incapacitated and unable to take the actions necessary to manage your assets? And frequently that's what it is. It's just a matter of they don't want to have somebody going in there now. Well, they need to have the power of attorney be a springing power of attorney. It's really important to talk to them about co-agents too. If maybe they want to have two people act as co-agents that require that any decisions be agreed upon between the two people. That's another kind of mechanism to make sure that one person doesn't have all the control. And then always, of course, naming alternates, so that if the person that is named isn't able or willing to serve, then you've got somebody else that can do that, especially if the principal at that time is unable to make any changes or appoint anybody. As I mentioned, you can grant single or multiple powers, or you can grant all of their powers. There's provisions in there to address specific transactions and to limit or expand those powers. The current forms do provide for compensation and reimbursement of expenses. I think if you don't pick either one, you're kind of stuck with what reasonable compensation is permitted, and what is reasonable. I think reasonable would be commensurate with the amount of time involved, the level of sophistication needed to make the decisions, the size of the estate, etc. So it's going to be really kind of up to the agent to do that, especially if the person is incapacitated and unable to give any kind of input. The other thing too, I think it's really important before I discuss gifts, is to explain to them, especially if you're dealing with people that are not quite as sophisticated as, a lot of people will think that a power of attorney is effective at death, or they think it's effective through their death, and that it avoids probate. And you want to make sure that you explain to them that as soon as you pass away, this document is null and void. It is not effective. You can also allow for gifts to be made. Most of the gifts that are permitted are these annual exclusion gifts, and they're usually people that have been making those kinds of gifts. And I ask the client, if you ever done annual exclusion gifts, is that something that you're interested in? If it's not, then I do not put that language in there. I do not allow them to make those gifts, or I counsel the client to not include that in there, and usually they won't. We discussed the springing and the things to consider. One thing too, if you're doing these powers of attorney and a will, I usually would like to include a HIPAA release, and I put the person that is identified as the agent on the HIPAA release, because if it's a springing power of attorney, and the person is only going to be able to act under the power of attorney if they have a medical letter, they've got some proof. Well, the doctor may not be willing to talk to them. So you always want to make sure that those persons are on the HIPAA release so that they can go to the doctor and obtain a letter that allows them to act under the power of attorney. All of these things that we're talking about are really important in how to avoid guardianship, and making sure that there's practices in place and in order for people to manage their affairs if they become incapacitated, and not have to go through the rigors of a guardianship. Final thoughts: ask lots of questions, really listen to your client. And if you're really listening, and you spend some time with them, you frequently, they get comfortable with you and they'll say things that'll lead to more questions. Always confirm information through the documentation. And it's not because you think your client's lying to you. It's just they may not understand what they're telling you, how it works, or they may not. Um, they may think that they have a beneficiary designation for certain accounts, and they just don't. So you always want to double check all of that. Be wary of the helpers. Again, a lot of times it's innocent, and it's, especially if you've got, mom who's a widow and she's only got one child. Well, of course, that child is going to be the one that's helping. They're going to be the natural person that's going to inherit everything. Think about it in the context of situation. But if you've got, a caregiver who's going to all of a sudden become a beneficiary, and there's multiple children, and especially if the children don't live here, that's usually a big red flag too. Is you have a lot of situations where, mom lives here and all the kids have grown up and they've moved to other parts of the country, and they just don't really have a clue as to what's going on, and it's not out of anything other than they're just not there day to day, and they've hired this person to help their mom, and all of a sudden they're really going to help mom create different planning. I always give the originals back to the clients, but I do like to retain copies, and I usually will I'll bind them, and we put them on a thumb drive, and we put that with the binder, and we deliver that to the client. And then I also will frequently send out the packet to other family members if that's what the client wants. I have a widow client who's got 3 kids, and all of them are equally sharing. There's no secrets. She wants them all to have the documents. And so we even provided binders for all of them and sent them out to them. So it's good to have copies on your, hard copies, but also to have them electronically so they're easy to send out. Okay, well, let's see here. I'm going to stop sharing. And I think we have, let's see. So the first question is, I'm going to do the Q&A since there's 3, and then I'll go down to the other. Can an over 18 stepchild witness the will of his stepmother? Yes, as long as he's not a beneficiary. Oh, that's done. Excuse me. What are the issues with blended families when a husband and wife have separate wills? Oh, goodness. Well, I mean, I don't know how to really answer that question other than to say a lot of different issues can come up. I think the first thing that comes to my mind is, if they're leaving their assets to different people, if the husband is leaving all of his assets to his children, or the wife's leaving all of her assets to her children, and they're not the same children, that's a big problem. It's not a big problem. It can create a lot of problems. And, especially if you have a widow who is not the who's not the, maybe not a beneficiary or not the executor, and they're having to deal with stepchildren if they don't get along. That can obviously create a lot of issues. Oh, okay, then we got that. So let me go to the chat here. Okay, go to the top. PowerPoint. Okay. Can you address informal marriages? Okay. I think really the best way to deal with that is just to state in the will, well, have your clients sign an informal marriage certificate. There are ways to document an informal marriage, and quite frankly, if they're not married, if they want to leave everything to their formally married person, then that's fine. They can just leave everything to them. If they don't want to leave everything to them, then that's a different issue. I think that the primary issue that comes up is going to be the homestead rights. A surviving spouse has a homestead right in real property that's their residence, at the time of death, at the time of their spouse's death, regardless of the characterization. If it was the deceased spouse's separate property, or if it was community property, the surviving spouse has the right to live in that house the rest of their life. And unfortunately, I've been involved in a few cases where the deceased spouse leaves his interest in the house to his children. Well, so then the surviving spouse co-owns the property with her stepchildren, which, as you can imagine, creates some issues. Is there a resource or way to see examples of wills or trusts that are drafted so as to have some point of reference as to what a well-drafted will or trust looks like? Especially when you're solo and you don't have access to forms, when you're in a firm, that can be difficult. I think the best way to do that is to sign up for some CLEs where they do have those documents. I think there's some CLEs through the State Bar and through UT that have, not Professor Featherston. I cannot believe I can't think of his name. He's the UT professor that anybody that's had a Barbary course had him teach, and his name is just escaping me, but he has done some. Johansson, thank you. Professor Johansson has some really, really good CLEs, and you might be able to go back in time and under the online library through the State Bar and find some where he has forms for his and her wills, single person, or a couple's will and a single person's will. And those are great. Those are really great to look at. When I was a brand new lawyer, about a year out of practice from a firm, I went out on my own and I attended all kinds of CLE and I got a hold of his forms, and it was really, really helpful to me to create my will forms. And also, I think if you do anything through DVAP has forms, so you can use those forms. And, don't be afraid to send emails, to lawyers. I mean, we should help each other be better lawyers. And I think sharing forms, it's not a big deal. I think you just have to be careful if you are sharing forms that you take names out. I think a lot of lawyers, and I know most of my partners have forms where they just have, they have literally the form, and then the paralegal goes in and plugs in the names. And so those can be easily shared. Let's see here. Let me make sure. Is there a resource? Okay. Are there any tips or special considerations when advising a couple where one is a non-citizen and they are being advised to develop a Q-tip for the marital spouse deduction for tax purposes? I am not going to be the person to answer your question on that. That's a little bit more complicated. That's not something you're going to probably ever have to deal with a DVAP client. And I think that goes a little bit beyond the scope of what we're here about today. I would talk to somebody that deals with more tax planning. And I'm sure there's some CLEs on the online library. And if you're not a member of the college State Bar, I think you can pay to have that membership. And you can go into the Texas Bar CLE in the online library, and you can have access to every single CLE going back to 20 years, or more. I think it actually goes back to 99. That'll allow you to look at all those CLEs. Helpers assist client at intake. I often ask for a few moments alone with the client in order to review critical distribution provisions and fiduciary appointments outside the helper's help. That's a helper's presence. That's the best practice, because sometimes people physically can't make it. They're mentally fine, but they physically can't get there. So that's a great practice. And there we go. Recording a presentation will be available to be viewed later. Sorry if anybody had any issues with their connection. I really enjoy the opportunity to speak. If anybody has any questions, feel free to email me. I'm going to put my email in here. And let's see here. I think that's just to the host and panelists. Let me see here. Everyone. Let's go again. LSS.legal. Great. didn't cover everything. There's so much more, I'm sure, and there's probably lots of lawyers on here today that know way more than I. So, you know, like I said, we should work with each other to be better lawyers. And if you see, you know, somebody that on there you want to ask questions of, that's what I did when I was a baby lawyer. I was fearless. I would call up somebody that I had never met before, but I knew that they were a good lawyer and just say, hey, can you give me a few minutes? And everybody was always very, very generous with their time. So thank you so much for the opportunity to speak. And thanks so much for the participation. And wow, we had 168 people on. It was great.
Thank you, Brandy, for your presentation and everyone for attending this afternoon. I did include the CLE number in the chat, but I'll say it briefly here, and then it'll also be emailed to all attendees following today's presentation. The course number is 174-150-105. Again, that is 174-150-105. Thank you, everyone, and we hope you have a good rest of your afternoon.
Thanks.